Hello, my name's Steve Fleury. I'm an attorney with Saxton & Stump's Long-Term Care Group, Healthcare and Employment Litigation Groups, and with my colleague who's here today, Rick Hackman. We're thrilled to be presenting to you, PHCA members, on the topic of COVID-19, the impacts on labor and employment for long-term care and personal care facilities. So I'm going to handle the first half of the presentation today. And then Rick's going to come on a little bit later, and I'll allow him to introduce himself further at that time. Moving on to our first slide, after our biographical information, we're going to cover three topics for you today. The first is going to be the definition of a healthcare provider under the FFCRA, which is the Families First Coronavirus Relief Act. We're also going to cover handling employee requests for leave for COVID-related reasons, whether that be for child care or otherwise. And a little later on in this presentation, Rick is going to talk to you about whether you can restrict employee vacation travel destinations to avoid some of the COVID hotspots, which of course changes from time to time, whether you can impose a quarantine on those who do visit COVID hotspots, and how to handle that from an employee pay perspective, whether that's paid or unpaid, and how exactly that might work. So turning to our first topic, who is a healthcare provider? Before we get into that, we're going to do a brief primer on the FFCRA, as that really is the crux of everything we're going to be talking about here today. So the FFCRA was passed pretty early on during this pandemic in March of this year, and it did a number of different things. But two of the biggest things, and certainly for today's purposes, is that it enacted paid sick leave and paid family medical leave for certain COVID-related reasons. So for nearly all public and private employers with less than 500 employees, the FFCRA is going to apply. And we'll talk about a couple exceptions to that later on during this presentation, but generally speaking, it has a pretty broad application. It provides employees of those covered employers with 2 weeks or up to 80 hours of paid sick leave at the employee's regular rate of pay, where the employee is unable to work because that employee is quarantined, and that can be pursuant to a federal, state, local government order, or upon the advice of a healthcare provider, and or that employee is experiencing COVID symptoms and seeking a medical diagnosis. Or, secondly, the employee would be entitled to 2 weeks or up to 80 hours of paid sick leave at 2/3 of that employee's regular rate of pay because that employee is unable to work because of a bona fide need to care for an individual who is subject to quarantine, or to care for a child under the age of 18 whose school or child care provider is closed or unavailable for reasons related to COVID. Now, on the slide at the bottom, you will also see, quote, and or an employee experiencing a substantially similar condition. That substantially similar condition refers to those conditions that the Secretary of Health and Human Services, HHS, has identified. And to date, as we sit here in October, the Secretary has not identified any other similar conditions at this point. So for purposes of today's presentation, we can disregard that component. And then lastly, and importantly, this is for only those employees who have been employed for a period of at least 30 days or more. Those employees are potentially entitled to up to 10 additional weeks of paid expanded family and medical leave, and this is at 2/3 the employee's regular rate of pay when that employee is unable to work because of a bona fide need for leave to care for a child whose school or child care provider is closed or unavailable for COVID-related reasons. And I want to make a brief point regarding regular rate of pay. We get a number of questions from our client regarding the calculation of an employee's regular rate of pay under these provisions. And the calculation is fairly straightforward for full or part-time employees with regular schedules, as I suspect that many of, for full and part-time employees with regular set schedules. When you have employees with irregular schedules, as I suspect many of you have, this is where you have to exercise quite a bit of caution. So if an employee has an irregular schedule but averages 40 hours or more per week over the preceding 6-month period, the employee is considered full-time and may take up to 80 hours of leave. So again, that's not especially complicated, but for part-time employees with irregular schedules who have worked at least 6 months, that employee may take up to 14 times the average number of hours that the employee was scheduled to work over the preceding 6-month period. And then finally, for part-time employees with irregular schedules who have worked less than 6 months, that employee is entitled to the number of hours 14 times the number of hours on average that the facility and the employee agreed he or she would work on each calendar day. If there was no agreement, then it's 14 times the average number of hours per day that employee was scheduled to work over the entire period of employment. So the bottom line is that when you're calculating the employee's regular rate of pay, particularly for those irregularly scheduled employees, you want to keep the calculator handy, and where necessary, certainly reach out to legal counsel or to someone within your organization that might be more familiar with this topic, because that is ultimately where a fair amount of litigation could ultimately arise under these FFCRA provisions. So be careful with that. So we covered previously that covered employers under the FFCRA, again, generally all public and private employers with less than 500 employees. The two big exceptions to that, and the first is rather limited, and we're not going to have time today to go into detail regarding all of the details of this exemption, but it exempts small businesses from providing paid sick leave and family and medical leave necessitated by certain specific reasons only, and only if that leave would, quote, jeopardize the viability of the business as a going concern, end quote. So the bar is very high, and there are several specific inquiries an employer must answer in order to establish whether the leave would in fact jeopardize the sustainability of the business. Now, the other exemption, which we're going to cover in a little more detail here in just a second, is broader in scope, and that is the exemption for employees who are classified as quote-unquote healthcare providers. So, like most of the regulations and guidance that have come out for all aspects of the FFCRA, it has substantially changed on what seems like a week-to-week basis since this guidance originally came out after the FFCRA was first introduced in March of this year. And, in many respects, that is to be expected, considering this is a new major piece of federal legislation that, hard to believe, is only approximately 7 months old at this time. But the definition of healthcare provider is one of those changes that have been made by the Department of Labor, and it's a fairly recent change of just about 1 month ago. Preliminarily, I want to note that this change does not affect the definition of healthcare provider for purposes of determining who may advise an employee of the need to quarantine. That is still a physician or a licensed medical professional. There is no change with respect to that definition. But what we're talking about here today is who an employer may consider a healthcare provider for purposes of determining whether he or she is exempt from the requirements of the FFCRA. So pre-September 16th, 2020, the Department of Labor defined healthcare provider broadly, and it was based very much on the nature of the employer's business. So more or less, if you worked for a physician's office, a hospital, a long-term care facility, you were considered a healthcare provider no matter what your actual job responsibilities were. So for example, a receptionist who had no clinical responsibilities whatsoever was considered a healthcare provider pre-September 16th, 2020. In August of this year, a New York federal judge vacated a number of FFCRA provisions, among them the definition of a healthcare provider. The court effectively said the definition was too broad. And while the court's ruling was only binding as to New York State, it did cause the Federal Department of Labor to go back to the drawing board. And in mid-September, we get the new definition of healthcare provider that is more narrow and based on the employee's role and job duties. So the new definition, of course, includes physicians and licensed professionals, but it also includes those, quote, employed to provide diagnostic, preventative, and/or treatment services, as well as those integrated with those services, and if not provided, it would adversely affect patient care. So your receptionist, using our last example, is no longer considered a healthcare provider, even though she's working in a long-term care facility, or a doctor's office or a hospital. Same with the billing clerks or your dining services crew at your facility. But it is still, under the current definition, the new definition, going to include your RNs, your LPNs, your CNAs. All of these folks are providing diagnostic, preventative, and/or treatment services, or working in conjunction with those services. And again, if those services would not provide it, would adversely affect patient care. So all of those individuals are still fitting within this narrower definition of healthcare provider. But again, it's still going to encompass a number of your employees. Switching to our second topic, request for leave for remote or hybrid learning. Remember that the FFCRA, from our beginning slide, provides up to 12 weeks of a combination of paid sick leave and expanded family and medical leave, all at 2/3 the regular rate of pay for an employee who is unable to work because their child's school or child care provider is closed or unavailable during COVID. So, with respect to schools, if the school is closed to in-person learning, the school is considered closed or unavailable under the Department of Labor regulations. However, if the school is open to in-person learning, but the parent is opting to keep the student home, then the school is open and the employee is not eligible for leave under those circumstances. If the school is engaging in hybrid learning, that is, certain days of remote learning in conjunction with certain days of in-person learning, the school is closed or unavailable only on those days that the school is not offering in-person learning. Also, please note that child care provider is broadly defined under the statute and includes not only traditional child care facilities, but also babysitters and relatives or friends who may provide child care at no cost and without a license, so long as they do so on a regular basis. And finally, the employee is only eligible for leave when the school or child care provider is unavailable if that employee is actually needed to care for the child during the time he or she is at home and no other suitable person is available to provide that care. So in terms of documentation, the employer is entitled to receive documentation from the employee with respect to his or her representation for their need for leave. In the case of a leave request due to the child care provider or school being closed, this is what the employer may request: the name of the child, the name of the provider or school, and an attestation that no other person is available to provide the care. If you as an employer have reasonable grounds to believe that the employee is not being truthful with you with respect to their representations on this documentation, I'd recommend that you reach out to your legal counsel to determine what sort of follow-up you as a facility may be able to perform. You have to be really careful here because the regulations are written in such a way to give the employee the benefit of the doubt in most instances. So you do have to exercise some level of concern in follow-up with respect to certain documentation that the employee may submit. We get a lot of questions concerning intermittent leave with respect to the FFCRA. Intermittent leave is only available if the employer agrees. This is not at all the case under your traditional FMLA, but with respect to the FFCRA and the employee's request for intermittent leave, the employer has a great deal of discretion on that. I should note that the Department of Labor regulations specifically encourage employers to liberally grant intermittent leave, but again, the employer is under no obligation to do so. I would also note that if you as the employer make the decision to voluntarily allow intermittent FFCRA leave to one employee, you should be doing it for all similarly situated employees. If you're not, you need to document in your records why you are ultimately going to allow intermittent for one employee, but not for other similarly situated employees. And this just goes back to basic good employer practice in terms of feathering your nest against liability. You want to ensure that your policies are evenly enforced without exemption as to all your employees wherever possible. And then finally, that last point is particularly important as well. Under hybrid learning, if the school is closed to in-person learning on, let's say, Monday, Wednesday, Friday, each day of that closure is going to be a separate reason for leave. It is not intermittent leave under the FFCRA, and therefore the employer cannot deny the employee leave in that instance. Same thing, remote or hybrid learning. Keep in mind that paid sick leave is in addition to any other leave provided for by the employer. That would include PTO by way of example. You want to differentiate between paid sick leave and emergency FMLA leave. The reason for that is really the third bullet point. In addition to keeping your records clear and keeping that documentation, having accurate documentation, should the leave ever be challenged in litigation. But the third point is particularly important, that emergency FMLA under the FFCRA counts toward 12 weeks of total FMLA leave during a 12-month period. And then turning to employee request for leave, when an employee has been advised to quarantine, again, the FFCRA provides 2 weeks, up to 80 hours for paid sick leave at that employee's regular rate of pay because he or she is quarantined pursuant to a government order or upon the advice of a medical professional, and or he or she is experiencing COVID symptoms and is seeking a medical diagnosis. The last part is important. An employee is not entitled to leave simply because he or she represents that they are experiencing COVID symptoms. Rather, you must be getting tested, seeing a physician, or be in the process of doing one of those two things to be eligible for leave. And again, minimal documentation is required of the employee. You may require that the employee identify his or her symptoms and a date for a COVID test and or a doctor's appointment, and nothing else. That's really it. However, I would note that if an employee were to take unpaid leave under traditional non-FFCRA FMLA leave, then the FMLA's documentation requirements would still apply. And at this point, I'm going to turn the presentation over to my colleague Rick to talk about challenges in long-term care.
Thank you, Steve. My name is Rick Hackman. I am the chair of Saxon & Stump's Labor and Employment Group. I'm happy to be here today. There's two topics I want to address briefly today. Challenges that you may experience with respect to long-term care. Number one, facility mandated quarantine requirements with respect to employees, and a few references to the return to work issues that you'll face. And then finally, essentially juggling staffing needs with employee leave requirements and what you can and cannot do. So employers are generally juggling two sets of requirements and recommendations. Beginning in April and on an ongoing basis since then, at least one time per month, we're getting new guidance or revised guidance that has been issued by either the CDC or the Pennsylvania Department of Health. Now, many of these guidances, again, are overlapping and more or less are tweaks to prior advice and must be read in conjunction with one another. So they don't all stand independently. The latest missive from the Pennsylvania Department of Health, actually it was just approximately 2 weeks ago, October 7, 2020, through the Health Alert Network. And that missive was entitled Long-Term Care Facility Guidance for Testing and Cohorting, Response to an Outbreak and Residents with Exposure to COVID-19. So the bulk of the guidance addresses what's happening with respect to outbreaks, testing your residents, and separating your residents in respective zones based on symptoms and exposure. With respect to cohorting residents, the October 7, 2020 release breaks it down into three areas. There's the red zone, the hot zone, of course, where facilities should keep residents with a positive test separate from others. There's a yellow zone which is for those who are potentially exposed, residents who maybe have symptoms but have tested negative, those who remain asymptomatic even though they have been exposed but are within 14 days of exposure. And finally, what you're doing there is essentially quarantine them. So we're breaking them up by red, yellow, and then lastly, green. So the green are obviously the unexposed to the COVID-19. With respect to cohorting, you want to segregate folks into areas of facility where staff are not typically sharing with other areas during one shift. The zones need to remain separate, no sharing of communal areas, and the zones should be clearly marked. So both staff, residents, and potentially, if allowed, any visitors will be aware of the various sectors. The October 7 release offered some recommendations based on zone segregation, and it sort of lists the staffing options from best to worst. So obviously, if you can keep the staff for one zone together in one zone and not have them move amongst zones, that would be your best options for staffing. The second best would be staff being assigned to specific zones, but occasionally, and I stress occasionally, need to cover staffing needs in other zones for certain shifts. Progressing with respect to options, the staff will always work in one zone during a shift, but work in different zones on different shifts. So if I'm working the overnight shift in a specific zone, that's great, but the next day, the following day, there's a staffing need in another zone, then I could be placed in that zone during the course of that shift. And then finally, essentially the last option, staffing needs to require staff work in more than one zone during a single shift. So this is where it becomes problematic when staff are going back and forth between various zones during the course of one shift. If possible, that needs to be limited to the key staff that you have, for example, RNs. With respect to exposure, so the high exposure level, essentially means prolonged close contact, 6 feet for 15 minutes or more with a patient, visitor, or coworker with confirmed COVID-19. And, to be considered part of this exposure level, it would involve no respirator or face mask or PPE of any sort, no eye protection, and gown, gloves, masks are absent when performing an aerosol generating procedure. Under those circumstances, for those who are exposed, and again, I'm referring to staff here, employees, they must be excluded from work for 14 days, and other staff who potentially may have been exposed are advised to monitor their symptoms during that time period. Obviously, if anyone else develops symptoms, or if the person exposed develops symptoms, they need to report that to the employer and seek testing as soon as possible. The subsequent or secondary level of exposure, the guidelines issued for that, would be a situation where there's no close contact and or wearing PPE. Under those circumstances, those individuals can essentially stay at work. There's no work restrictions. Obviously, you want to continue to follow all PPE guidelines and monitor symptoms on an ongoing basis. And again, as with all of this, if there's any symptoms that may develop, they want to report and seek testing. Back to the October 7, 2020 release, it also mentions briefly return to work criteria, staff testing. A lot of this refers to prior guidance from both the Pennsylvania Department of Health and the CDC. First and foremost, obviously staff who test positive and are symptomatic should be excluded from work until they meet prior return to work criteria, which we'll discuss momentarily. Asymptomatic staff who test positive should be excluded for 10 days following that first positive test. And there are issues that we get questions about with respect to asymptomatic staff who refuse to be tested. There's sort of a differing of opinion here between what the Pennsylvania Department of Health is saying and what the CDC is saying. With respect to the Pennsylvania Department of Health, between what the Pennsylvania Department of Health is saying and the EEOC is saying. Under the circumstances, asymptomatic staff may refuse to be tested according to the Pennsylvania Department of Health, but they should not care for residents in the green zones. So if there is a situation where there has been an exposure, there's no symptoms, despite that, they can refuse to be tested before they come into work, but they cannot work with individuals who are in the non-exposed green zone. And I'll talk a little bit about what the EEOC has said about this momentarily. With respect to return to work, the October 7, 2020 health release refers back to the July 18, 2020 health release, which again leads back to my point of these various releases have to be read in conjunction with one another. This release in July was set forth to align the guidance with the return to work criteria for the CDC. The notable issue with respect to the July 18, 2020 release as far as return to work involves a move from test-based strategy for return to work to a symptom-based strategy for return to work. The CDC determined that test-based strategy for return to work is no longer recommended because it may result in cases excluding work personnel who continue to shed the virus but are no longer detectable. So obviously a negative test one day does not mean the following day it will also show up negative. CDC had concerns with respect to that. So we moved to a symptom-based strategy for return to work. With respect to mild to moderate illness and an individual staff member who is not severely immunocompromised, they may return when at least 10 days have passed since that first symptom appeared and at least 24 hours without fever-reducing medication. And obviously the symptoms would have to be improved. If it's an individual who's not severely immunocompromised and asymptomatic, meaning no symptoms whatsoever compared to the mild and moderate illness referenced above, they may return when at least 10 days have passed since the first positive test. With respect to other individuals who may be severely ill or who are severely immunocompromised, the waiting period is at least 20 days since symptoms first appeared, and at least 24 hours again, and at least 24 hours have passed without a fever, subject to fever-reducing medications, and the symptoms have improved. Now, with respect to these individuals, the CDC does reference that they may return to work when at least 20 days have passed. However, if I know a lot of facilities, a lot of our clients, not so much anymore, but earlier were operating under critical staff shortages. And so if that's in fact the case, and that's currently your situation, you do have the ability, the CDC does say that you can reduce that 20-day time period to 15 days. So the July 18, 2020 release, again, even though it now references reliance on the symptom-based strategy platform, they do mention, again, test-based strategy. It's something that they now say that could be considered, but is no longer really recommended. Or reasons, again, the limited value because of prolonged viral shedding. When you're talking about the test-based strategy, symptomatic staff may return following no fever, improvement in symptoms, and negative results from at least 2 consecutive respiratory specimens collected at least 24 hours apart. So again, considering the various strategies, what the CDC and the Pennsylvania Department of Health now recommend and recognize to be the most efficient would be the symptom-based strategy. This, again, with respect to the test-based strategy, if someone's asymptomatic after a positive test, 2 more tests, 2 more negative tests, and they can come back to work. So with respect to return to work practices overall, common sense, adhere to the guidelines you should already have in place, all required PPE, social distancing where possible, and disinfection and hand washing. As far as mitigating personnel shortages, there are various strategies you can use under the circumstances. People have vacation. Now, this is a fine line. I mean, you can postpone elective time off from work if someone has a vacation scheduled, but you also have to realize the mental health aspects associated with this, because staff are currently under a lot of pressure, a lot of stress, and frankly, a vacation may be exactly what they need. Another strategy with respect to return to work personnel, if they are well enough to return before the recommendations of the DOH and the CDC, we referenced that previously. The way to break up the staff would be to have the staff with suspected or confirmed COVID perform job duties where they don't interact with others. If that's not possible, if these are direct care staff, then under those circumstances, they should be providing direct care to patients who are confirmed positive, back to the red zone situation. Next in line would be staff confirmed positive, provide direct care to patients with suspected COVID, and then as a last resort, allow staff who are confirmed positive to provide direct care to patients without suspected or confirmed COVID. Now that, of course, is the most risky proposition of all of those. So I mentioned previously the EEOC and the practice's ADA obligation. So as many know, the ADA, the Americans with Disabilities Act, prohibits discrimination against qualified individuals with a disability, and also prohibits certain medical inquiries of individuals, of employees in the workplace. Technically and generally, medical exams for return to work purposes are prohibited under the Americans with Disabilities Act. And so during the course of the pandemic, the Equal Employment Opportunity Commission has issued various guidances themselves with respect to how employers are supposed to treat employees who may be symptomatic, who may refuse to test, and just generally what employers are permitted to do in the workplace now under the stress of the pandemic. So there's some things that are permissible now that were not permissible previously under the ADA and pursuant to the EEOC. So first and foremost, you are permitted as a practice to ask employees if they're experiencing symptoms. And although it's technically a medical examination under the ADA, temperatures may be taken before employees come into work. Also, you can require employees to stay home if they are experiencing symptoms, and we'll talk a little bit about how you handle that from a leave perspective. You also may require testing to return to work. So the one caveat with respect to that is that the EEOC does not permit employers to require antibody tests to return to work because they've been currently deemed somewhat unreliable. So it would have to be the typical swab test under those circumstances. And you may ask all employees if they were diagnosed with COVID-19 or whether they have been tested, but you need to be careful here, and it goes back to your normal HR practice of not singling out specific employees. So if you're going to ask that question, make sure you ask it of everyone and not just select individuals. So continuing on with respect to the practice's obligations under the ADA, you may not ask employees physically entering the workplace whether family members tested positive or experiencing symptoms. Now, this is something that I've run into on a number of occasions that employers have been doing. Limiting it to family members only violates GINA, which is the Genetic Information Non-Disclosure Act. However, the way around that is you can ask if they were in contact with anyone who has tested positive or experiencing symptoms. You don't need to necessarily know it was their family member, but you want to ask them the broader question of if there's anyone who they've run into or close to that have tested positive. As an employer, you may exclude from work employees who refuse to allow their temperature to be taken or refuse to answer questions about whether they have COVID-19 symptoms or have been tested. Also, one thing that you can do now that you could not do before under the ADA is you can ask an employee why he or she was absent from work. Instead of your typical, well, I was out sick, you get a doctor's excuse. You're not necessarily entitled to a lot of medical information. Under the new EEOC guidance with respect to the pandemic, you can ask specifically the reasons for the work absence. Also, when an employee returns from travel during a pandemic, you may ask where the person has traveled. As referenced by Steve earlier in his presentation at the very beginning, discussions about hotspots and prohibiting employees from traveling to hotspots are certainly within your right as an employer. Confidentiality obligations under the ADA, they've always been there and they remain. Any information you receive from employees based on the fact that they have been tested or whether they're currently experiencing symptoms or whether they have had contact with anyone who had symptoms, that all needs to remain confidential. You may keep a log of temperature results, but again, that must be kept confidential. Further, if you do have an individual who has tested positive, you are permitted to disclose that employee's name to a public health agency who's tracking this for purposes of contact tracing. Further, an employee may disclose to a supervisor that a coworker is experiencing symptoms. So in the past, someone has some issue related to a disability, let's say it's a learning disability of some sort, and another employee recognizes that, they can mention to a supervisor, hey, it seems like Rick and Steve are having trouble keeping up with their work, maybe you want to talk to them. But typically it's not something that other employees are going to report on a regular basis to their supervisor. Under these circumstances, if an employee witnesses someone who's perhaps feverish, cough, everything else associated with COVID-19, they should be reporting that to their supervisor. One other question we get frequently, I have an employee who's in a high-risk category either because of their age or underlying health conditions. Under those circumstances, the EEOC and the ADA do not permit the employer to simply exclude that employee from the workplace because of that, nor can they take any other adverse action. And it has to be solely related to that particular issue. You can't just simply exclude someone from the workplace because they're at a higher risk for severe illness if they get COVID-19. Circling back just briefly to what Steve mentioned with respect to employee time off, it's important to remember that the employee paid sick leave, the paid leave that Steve referenced earlier, does not reduce or eliminate any other employee benefit to which the employee may be entitled. So, for example, if you as a practice provide your employees with 10 days of PTO a year, the additional 10 days allowed under the EP for purposes of the EPSL is an addition, that should be 10 days rather than 20, that are provided by the employer for a total of 20 days. You cannot run these concurrently. In other words, you can't say, okay, you're entitled to the FFCRA leave because you're experiencing COVID symptoms and seeking a medical diagnosis, but you have to run your vacation time concurrently with that. That does not work and is not permitted. With respect to the extended FMLA, the EFMLA that again Steve briefly mentioned, typical FMLA allows employers to require their employees to substitute accrued paid leave for unpaid FMLA leave. Similarly, the expanded FMLA regs allow employers to require that applicable company leaves run concurrently with the expanded FMLA leave, and that's in contrast to the EPSL rules, which we just discussed, which do not permit you to do that. But generally, again, keep in mind the reasons for the leave. The leave under the EFMLA is limited to those company-provided leaves that would otherwise apply when an employee must care for his or her child due to a COVID-19 related reason. Restricting travel to hotspots, it is permissible for you as an employer to protect your employees and protect your patients by restricting employee travel to hotspots. And it's also permissible to require them to quarantine upon return from hotspots. And if they return, if they don't meet the requirements for the emergency paid sick leave, such as experiencing symptoms, seeking a medical diagnosis, being ordered by a physician to quarantine, and so on and so forth, you may require them to use their PTO for that time off. And if there's no PTO available to them, that time off may be unpaid. So in conclusion, again, it all boils down to and wraps up with respect to your establishing policies, practices, and procedures for all these issues and enforcing those policies and procedures and making sure there's equal application of those policies and procedures, because under the circumstances, when you start picking and choosing as to what to allow and what not to allow, that's when you're really going to get yourself in trouble with respect to both litigation and employee morale issues. Thank you very much.
Thank you.